Can merely watching or downloading child sexual exploitation material be treated as a crime in India, even if you don't share it? In a landmark 2024 judgment, the Supreme Court answered this question in the case of Just Rights for Children Alliance versus S.Harish. Today, we will analyze facts of the case, relevant provisions under the POCSO and the IT Act, Supreme Court's reasoning, final ruling, and why this judgment is legally and socially important. Let us understand facts of the case. A cyber tipline report flagged that accused had been downloading and viewing child sexual exploitation material for nearly 2 years. Forensic analysis of his mobile phone revealed explicit material involving minors. Thereafter, FIR was registered under Section 67B of the IT Act 2000, Section 14, subsection 1 of the POCSO Act. Later, it was modified to Section 15, subsection 1 of the POCSO Act. However, the Madras High Court quashed the FIR, stating that mere viewing or downloading without publishing or transmitting is not an offense. Thereafter, the matter then reached the Supreme Court. Let us understand the relevant legal provisions. Under the Protection of Children from Sexual Offences Act, Section 40, Section 15, subsection 1, and Section 30. Section 40 deals with the punishment for the use of a child for pornographic purposes. Section 50, subsection 1 deals with punishment for storage or possession of pornographic material involving a child if the person fails to delete or report it. Section 30 deals with the presumption of culpable mental state, means the court can presume intention unless the accused proves otherwise. Next is under the IT Act 2000, Section 67B. It deals with the punishment for publishing, transmitting, browsing, downloading, advertising, promoting, or distributing material depicting children in a sexually explicit acts. There were 3 issues before the Supreme Court. First was, is mere possession or viewing of child sexually explicit material an offense? Second was, does failure to delete or report amount to criminal intent? And third, can High Court quash such proceedings under Section 482 of CRPC? Let us now understand the Supreme Court's analysis. First is, possession itself is an offense. The court held that Section 15 of the POCSO Act criminalizes storage and possession even without the proof of sharing. Watching and retaining such material fuels the demand and perpetuates exploitation. Child pornography is not a victimless crime. Secondly, the concept of constructive possession. The court clarified that the possession includes physical storage, digital storage, control over material, and even temporary downloads can amount to possession. Third, the presumption under Section 30 of the POCSO Act. The Supreme Court said that the presumption of intention applies at trial. Accused must explain why such material was stored. High Court should not prematurely quash the proceedings. Supreme Court criticized High Court as well. The Supreme Court held that the Madras High Court misinterpreted Section 15, ignored the legislative intent, and incorrectly treated the viewing as harmless. Final judgment of the Supreme Court. Supreme Court set aside Madras High Court order, criminal proceedings restored, clear declaration, viewing, storing or possessing child sexual exploitation material is punishable under POCSO. Significance of this judgment is that it strengthens child protection laws. It expands digital accountability. It aligns Indian law with the global anti-exploitation standards, and it sends a strong message that online anonymity is not an immunity. This judgment closes the loophole that only sharing is punishable. The Supreme Court has made it clear, child sexual exploitation material in any form, whether shared or privately stored, is a serious criminal offense. The law protects children not only from the physical abuse, but also from digital exploitation. If you found this analysis helpful, please like the video and subscribe to the channel. Thank you.